Good day. My name is Mark Malore. I'm a principal here at the Malore Law Firm, where we specialize in construction litigation. I wanted to speak with my clients in Moreno Valley in particular. I've got commercial clientele in Moreno Valley that are having problems specifically with getting paid on projects. So I wanted to address a couple of suggestions that I think could help you, even before you have to come see an attorney, get paid on the project. What do I mean? Well, the first thing you can do is file and serve by mail, certified mail, return receipt requested your California 20-day preliminary notice. If you're a subcontractor or a material man on a project, you're not the general contractor contracting directly with the owner, then you need to enforce your mechanics lien rights. And the first step to doing so is sending out the 20-day preliminary notice by certified mail, return receipt request. Make sure you keep those cards with you as part of your file. And you want to send those out to the owner of the project, the general contractor, and any lenders on the project to notify them that you're on the project doing work for the general contractor or doing work for a subcontractor on the project, or you're supplying materials to a subcontractor or a general contractor on the project. That's so very important. And that's the first step to getting paid. You want to make sure that you send that off also within the first 20 days that you step foot on the project. Either put the shovel to the ground or deliver materials to the project. You want to make sure that you mail that out within the first 20 days, because the 20-day preliminary notice counts back 20 days from the date of mailing to cover any work you did within that time. If you did work before that 20-day period count back, it's not technically going to be covered under the 20-day preliminary notice. But the 20-day preliminary notice is important for another reason. That is, it's a prerequisite to recording a mechanics lien. Once you record a mechanics lien on a project, that is essentially what's going to encumber the project to help get you paid. But if you haven't done your 20-day preliminary notice as a subcontractor or a material man, you won't be able to enforce those mechanics lien rights, because the mechanics lien will have been filed incorrectly. So we want to make sure we do the 20-day preliminary notice, then recording the mechanics lien. What's the next step, however, that I have problems with my contractors in this process? The next step that's so very important is to make sure that within 90 days from the recording date of that mechanics lien, you come see someone like myself or your own attorney to file a lawsuit to enforce your mechanics lien rights. If you fail to file a lawsuit within a 90-day time, your mechanics lien rights will go away and disappear. You won't be able to enforce those mechanics lien rights against the property, which will essentially mean that your recording of the mechanics lien has no net effect. And in fact, if the attorney's sharp, they'll do what I do many times, and that is they'll wait the period of time for the mechanic to file a lawsuit, and if they haven't done so to enforce their mechanics lien rights, I'll file a special motion in court to have the mechanics lien dismissed if you fail to dismiss it after I write you a letter. Doing so will subject you to an award of attorney's fees and costs in having to go to the court to get the court to order that. But the law is very specific and very clear that if you haven't enforced your mechanics lien rights, you can't continue to maintain a mechanics lien on a particular property. But those two things are essential for me as an attorney to recover the unpaid contract price that you agreed to in performing your work on a particular contract or a particular project. So very important. Many times I can, absent litigation or absent expensive litigation, recover those contract funds in settling the case, which I wouldn't have been able to do had we not had a mechanics lien recorded and filed properly and a 20-day preliminary notice backing that up. Once those are done, however, it gives me a lot of power in the process to negotiate on your behalf, avoid expensive attorney's fees, and get you paid. Anyway, some pointers to point out: if you have a specific situation that is troubling you, or you have particular facts that you're questioning with relationship to those items, feel free to give me a call. Mark Malore, construction attorney at the Malore Law Firm. You can reach me, telephone number 951-222-2100, or malorelawfirm.com at our website. We'd be happy to meet with you. Thanks so much for your attention.